If any fundamental assumption underlies our system, it is that guilt is personal and not inheritable. Even if all of one's antecedents had been convicted of treason, the Constitution forbids its penalties to be visited upon him, for it provides that no attainder shall work corruption of blood or forfeiture except during the life of the person attained. These were the wise words of Justice Robert Jackson from an opinion written in 1944. Unfortunately, it was a dissenting opinion. He did not prevail. The majority, in that case, Korematsu versus the United States, shamefully held that a U.S. citizen could be punished and imprisoned based on nothing more than his racial heritage. In that case, it was Japanese heritage. The majority's decision in Korematsu would eventually come to be recognized as the miscarriage of justice that it was. And in 2018, a majority of this court wrote, "Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and to be clear, has no place in law under the Constitution." Fortunately, though it may take time, the Supreme Court does have a history of correcting its prior mistakes in the area of racial discrimination. And with the cases that we'll hear tomorrow, that opportunity is more opportune than most, because the court that issued the Grutter decision in 2003, allowing race-based admissions policies, said explicitly, "We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today." Since it was issued, Grutter has allowed race-based policies that have harmed students, dashed dreams, and denied students, many of them first or second generation Americans, the opportunities they worked so hard to earn. Opportunities that in many cases their parents and grandparents sacrificed everything to make available to them by coming to this country and starting anew, against all odds and with nothing. Meanwhile, the promised benefits of Grutter have never materialized. The purported advancements are nowhere to be found, and we are less united, not more, as a nation. Some of us could have predicted that result in 2003. But the Supreme Court now has the opportunity to formally return to fundamentals. When it comes to race, if there is separate, there can be no equal. And no amount of racial discrimination is a legally permissible amount of racial discrimination. The late Justice Scalia wrote, "In the eyes of the government, we are just one race. It is American." Let's hope and pray the court issues an opinion that makes us proud as exactly that, as Americans. My name is Tyler Brooks. Thank you so much for the privilege of speaking with you, and thank you again for inviting me.